At its upcoming meeting, the Federal Communications Commission is expected to overturn 2015 rules on net neutrality that prohibit Internet service providers, or ISPs, from blocking and slowing certain online content. Up next, a panel of industry analysts talk about what the changes will mean for investment, innovation, and consumers, and what the congressional role should be moving forward. Speakers include FCC Republican Commissioner Brendan Carr, who gave some opening remarks. This is about an hour, 20 minutes. It was hosted by the American Consumer Institute.
So I'm Steve Posiansk. I'm with the American Consumer Institute. We're a 501c3 educational research group. It's a pleasure to be here today, and thank you all for coming. Of importance is on Thursday, the Federal Communications Commission holds one of its December open meeting and deals with one of several very important topics. And the issue today is the order to restore the Internet freedom, which includes a number of important provisions. One is classifying broadband access services as an information service, as it was once before, removing the ambiguous Internet conduct standard and the bright line rules, reestablishing the private mobile service classification for mobile broadband, and promoting Internet service provider transparency, among other things. And the transparency issue is very important to us because it helps give consumers better information to make better decisions. But there's a lot of noise out there, confusion, misinformation on what this will mean for consumers. And today we have a panel of experts that will address the issues. But first, I'd like to introduce a special guest to give remarks. And we're so glad you were able to make it and join us today. The FCC Commissioner was unanimously confirmed to the Senate and took office. This Commissioner Brendan Carr. Before he became Commissioner at the FCC, he served as General Counsel for the FCC, and prior to this, he was the lead advisor to the FCC Commissioner Ajit Pai on wireless, public safety, and international issues. And before that, he worked as an attorney for the FCC's Office of General Counsel. Prior to joining this commission in 2012, Commissioner Carr was an attorney for Wiley Rein, dealt with a lot of issues, including telecommunications and communications regulatory law. The full bio for all of our speakers today are available on your chairs, so I won't go any further with this. I just, think this is a wonderful event. I think there's a lot to be learned on this issue. Let me just say, here to talk about and give remarks on what what this will mean to the public in general. It's my great pleasure to introduce Commissioner Brendan Carr. Thank you.
Thanks, Steve, for that kind introduction. It's great to be with you today. I just want to offer some brief opening remarks before turning it over to the panel. Happy to talk a little bit about the FCC's Restoring Internet Freedom proceeding. In my view, this is a really great moment for consumers, for innovation, and for freedom. In 2 days, the FCC is going to vote to reverse an Obama-era FCC's unprecedented decision to apply Title II regulations to Internet access services. This 2-year experiment has failed. We've seen investment in broadband decline. We've seen ISPs pull back on deployments, and we've seen innovative new services kept on the shelf. All of this has harmed consumers. Before the FCC's 2015 decision, consumers enjoyed a free and open internet. This wasn't because the FCC had Title II in place, it didn't. It was because the FCC had this long-standing approach. For 20 years, we abided by Congress's direction, a bipartisan decision that the internet should be allowed to flourish free from heavy-handed government regulation. This was not a complete laissez-faire environment. This was not no holds bar. If you think back to 2015, that's the framework that we're going back to. Consumers were protected, innovators were allowed to innovate, and we saw the internet in the U.S. become the greatest success story that we've seen. We had over $1.5 trillion in investment. Businesses of all sizes, from startups to large corporations, launched and succeeded. I'm really excited that after this, again, 2-year detour, we're going back to that same regulatory framework, that tried and true approach. Now, if you step back, I'm sure you've seen, I've seen, there's a lot of colorful rhetoric that surrounds the FCC's decision. In some extent, the fake news stories about what the FCC is doing are trending faster than the real ones. So I want to try to dispel some of that. Now, obviously, the passion that's out there is really understandable. This is the intersection of the government and the internet. And Americans cherish the free and open internet. They cherish their experiences. But I think we have to bust some of the myths that are out there. A lot of what I'm seeing is what I call the great Title II head fake, which is attributing to Title II things that Title II simply does not do. One of the ones that I've seen a lot of, and that maybe you've seen it as well, is this Portuguese internet meme, or the cableization of the internet. It's this claim that by repealing Title II, ISPs will be free for the first time to charge you for bundled access to the internet, or make you pay per website or for packages of websites, similar, according to the allegations, as what goes on in the cable space. This is not true. The FCC's Title II decision specifically determined that if ISPs want to offer bundled or curated internet packages, they're allowed to do so. So the FCC's decision repealing Title II does not change the law on the legality of those curated services. Another claim that you may have seen is that the FCC's vote is going to raise rates for consumers, that ISPs will be free to start charging consumers a lot more. Again, this isn't true. The 2015 FCC decision, the majority went to great pains to state that their approach was not going to result in rate regulation or government control of the rates that are charged to consumers. So again, we're not opening the door to ISPs having different ability to charge consumers than what is currently the place with Title II in place. Another claim that I've seen is that ISPs are now going to be free to block websites or throttle or create fast lanes and slow lanes on the internet. Again, Title II is not the thin line between where we are and that conduct taking place. If you look at the D.C. Circuit decision that reviewed the FCC's 2015 decision, it expressly said that ISPs can block, they can throttle, they can do fast lanes under Title II, provided that they disclose to consumers that they're engaging in that conduct. The court even said there's no dispute that that's the case. So again, repealing Title II is not going to change the law with respect to that sort of conduct. We've also heard claims that the FCC's decision is going to be legally unsustainable or somehow unlawful. Again, this is not the case. The Supreme Court in 2005, in fact, the only time the Supreme Court has spoken to the regulatory classification of the internet, upheld the FCC's 2002 decision that found that broadband internet access service is a Title I information service. So again, that claim doesn't withhold scrutiny. And I also want to take a second to, again, emphasize that we aren't experimenting with some new or radical approach that is going to give ISPs free rein to do whatever they want on the internet. The Title I framework that we are voting to put back in place includes robust consumer protections. One that I'll start with is one that the D.C. Circuit found persuasive, which is market forces. When the D.C. Circuit observed that ISPs are free to engage in blocking and throttling and paid prioritization under the Title II framework, it said there's a reason why ISPs aren't doing it. The D.C. Circuit said it's fear of subscriber losses, market forces. Now, I know there's many people that won't accept market forces as a solution, either in the broadband market or otherwise. So the FCC and our Title I approach, we're not relying purely on market forces. I want to highlight a couple of the consumer protections that are staying in place. First, consumers are actually getting back strong consumer protection provisions. The Federal Trade Commission is our nation's premier consumer protection agency. In 2015, when the FCC voted to move to Title II, that decision as a legal matter stripped the FTC of 100% of its authority to protect consumers with respect to ISPs. That was a loss for consumers that they're getting back as a result of this decision. Second, the Federal Trade Commission has been the nation's premier privacy enforcement agency. It brought over 500 enforcement cases, including against ISPs. Again, when the FCC voted in 2015, it created a donut hole where consumers had immediately fewer online protections than they did before that decision. That donut hole is where we are today. After the vote on Thursday, consumers are going to get back strong online privacy protections that can be enforced by the FTC. Third, there's federal antitrust laws. Section 1 of the Sherman Act makes clear that if an ISP enters an agreement that involves anti-competitively blocking or throttling websites, that's going to be per se unlawful under the Sherman Act. Section 2 of the Sherman Act applies to vertically integrated ISPs. So if an ISP is vertically integrated and attempts to unfairly or anti-competitively discriminate against another provider that's unaffiliated in terms of its content, that's subject to being found unlawful under Section 2 of the Sherman Act. And fourth, we have state attorney generals and state consumer protection laws that are going to continue to apply. And this is one where I think there's been some confusion. The FCC's order, which is public and you can read it, makes clear that state-level net neutrality laws are preempted as a matter of law because they would conflict with the FCC's decision in its Title I decision. At the same time, it's clear that general state-level consumer protection laws, as they would apply to ISPs, are not preempted. So consumers get to continue to benefit from those protections. And then finally, there's a transparency rule. The FCC is adopting a rule that is likely more robust than what you would see purely from an FTC-based regime. So it ensures that consumers have full disclosure about the services they're getting, and if providers don't live up to those disclosures, the FTC is empowered to take enforcement action. And again, there's also this claim that somehow the FTC's regime is going to be more difficult to enforce because there's this claim that it doesn't have rules, unlike the FCC's approach. But again, I think this point misses the mark. At the FCC, we have a law, which right now are the FCC's Title II rules, but those rules are not self-enforcing. You then take enforcement action against that standard. The same is going to be true after our vote with respect to the FTC. The FTC has legal standards, has precedents out there. I've walked through some of them, what they are. And again, just like the FCC would, the FTC can take enforcement action to ensure that consumers are protected. So again, I think that this is really a great moment for consumers. We're getting back to the same regime that governed for 20 years, a regime that had robust consumer protections, a regime that saw online providers, edge providers launch and thrive, consumers benefit, consumers being protected. So this is not some sort of new experiment with an entirely radical new free market approach. There's robust consumer protections in place. I'm really excited about it. Again, this is a 2-year detour that the FCC was ultimately pushed into as a Senate committee found through political pressure from the White House. It was not a place the Senate committee found in terms of full Title II that the FCC was going to go based on its own independent judgment. So I think it's great that we're getting back to that, what had been a longstanding bipartisan consensus. With that, I'm happy to take a couple questions. Putting back my old formal general counsel hat on, I'll say that we are in the sunshine period at the FCC, which is a period that essentially prohibits lobbying of decision makers during this period. So to speak in legalese for a little bit, you cannot make a presentation to me that goes to the merits or outcome of the FCC's proceeding. If you have a question that you don't think falls within that, feel free to ask it. If you are not certain, probably best not to say anything. And then we can sort of transition ultimately to the panel. Thanks.
Do we have any questions?
Commissioner, I think they may think it's difficult to ask a question that is completely devoid of a presentation. So I think your caution was perhaps well taken. But anyone have a question that's not a presentation and Okay, I think probably would have some other would-be presenters, but that wouldn't be appropriate, as you noted.
Yeah. Great. Thanks very much.
So everyone, thank Commissioner Carr.
Thank you, Commissioner Carr. So it sounds to me that to some extent we have some regulations that were put in place to fix something that was not a problem, and without any evidence of market failure to justify a remedy, and all in the name of benefiting consumers. But with that, it seems like there's no surprise that we've seen some declining investment since 2015. So, I mean, how did we get there? What are the various aspects of the provisions of the order? What does the FCC need to do? How will restoring internet freedom affect consumers, investors, innovators? Does Congress ultimately need to have a role in all of this? So there's a number of issues that I like, teed up to be considered. With that, today we have an expert panel to clear up some of these and other important questions on restoring internet freedom. Moderating on the panel today is Randolph May. Randolph is a founder and president of the Free State Foundation. Earlier, he worked in policy research for think tank and practiced communications and regulatory law at major law firms, and prior to this, he served as Assistant General Counsel and Associate General Counsel for the Federal Communications Commission. Again, the full bios have been distributed. So, Randy, as always, it's an honor to have you join us today.
Steve, first of all, thanks very much for organizing this program. Obviously, it couldn't be more timely. And thanks to the American Consumer Institute for all the work that you do. So we're going to jump right in, and what I'm going to do is just introduce the panelists just by their affiliation, and then I'm going to ask them to speak initially no more than 5 minutes, and less than 5 minutes will be fine, maybe even preferred, because we're going to make sure we have time for questions. And unlike with regard to Commissioner Carr, you can absolutely, well, no, I don't want to put it that way, but you don't have to be quite as careful in asking your question to these noted panelists, because they're not covered by the Sunshine Act. So we do want to have time for questions. I want to say one thing briefly before I introduce the panelists and get started, just on my own behalf. I was Associate General Counsel at the FCC from 1978 to 81, had started doing communications law and policy even before that. So it's been a long time that I've been watching the FCC. And I want to tell you that I've got a concern really about the way that in a proceeding like this, the comment process, in my view, really has been subject to some distortion. Public participation is obviously welcome. It's important. Everyone can file a comment that wants to and should. But when you get into arguments about, in this case with 20 million comments filed, when you argue about whether 50,000 are valid or not, whatever, ultimately what's happening now disturbs me, because I think at bottom it diminishes the notion ultimately of the expertise of the FCC and the FCC's institutional integrity and the role of expertise. So, I hope we don't, go too far down that road, because ultimately what's going to occur Thursday shouldn't be based, and is not going to be based on the vote, how many comments are for and against a particular proposal. That shouldn't be the way the process works, and I think that's important to understand. If that were the way the process worked, then we really wouldn't need the FCC really to make that decision, would we? So I think that's important. So with that, I'm going to tell you who's on the panel. We have Katie McAuliffe, Executive Director of Digital Liberty, Baron Soka, who is the President of Tech Freedom, Shane Tews, Fellow at the American Enterprise Institute, and of course, Steve Posiak, who's the President of American Consumer Institute, who's putting on this program today. I think what I want to do is ask, now remember, the speakers are only going to speak at most for 5 minutes. I want to ask Baron if he'll lead off. He's been a leader in exploring the legal ramifications of the FCC's action. He's done that for a long time, and I think he'll probably agree with me, maybe not, but if the FCC doesn't have the legal authority to do to maintain these rules, then that goes a long way to answering the question as to what the FCC should do. So I'm going to ask Baron whether he'll speak first.
Thanks, Randy. So, in fact, that's the first question to be asked. And if the answer is no, the FCC determines it doesn't have authority, that's it. Game over. You're done. This is how agencies are supposed to work. You don't start with policy questions. You don't start by looking at comments. You start by asking what authority you have, you can validly claim, and then if you have authority, then using that to the extent that you can. And that's exactly what the agency's done here. The draft order, the one that's going to be voted on this week, concludes that the two major claims of authority made by the Obama-era FCC were mistaken. That is, 2010 claiming that Section 706 was an independent grant of authority to let the agency have free rein to regulate communication services, and then in 2015 that broadband is a Title II service. The FCC is reversing both of those claims, and when it does that, it effectively at that point says that there is no longer any basis for the net neutrality rules except for, with the important exception, the transparency rule. Judge Silberman back in 2014 in the Verizon decision noted that the FCC had always argued that there was another simpler basis for upholding that transparency rule, which I could talk about later. And it's on that basis that the FCC is maintaining that rule. So it's in that sense that we are reverting back to the status quo ante, and that this is really, at heart, as a legal issue, really should not be controversial. And if anything, people who, across the political spectrum, who are worried about the government claiming too much power over the internet, and in particular, who might be afraid of what this administration might do over the internet, should be applauding this decision for the same reasons that the Electronic Frontier Foundation back in 2008 to 2010 was warning that the previous claim of authority over the internet that had been made by Chairman Kevin Martin was a Trojan horse for broader regulation of the internet. I would say the same things about these two claims of authority, and that's why Tech Freedom has joined the lawsuit against the FCC's claims of authority, joined by not broadband providers, but small entrepreneurs and innovators who want to offer VoIP services, voice over internet services, who are afraid that the FCC's legal interpretation opened the door not only to blocking the services that they want to offer, but to those services themselves being subject to Title II regulation because, and this is very important, the 2015 order not only said that broadband in general is a Title II service, but it had to go to great lengths to justify reclassifying mobile broadband. And it did so by essentially saying that anything that uses an IP address could be subject to Title II. Well, that to us effectively undoes the line that the FCC drew back in 2004 between the internet and the telephone network and opens the door to the FCC regulating the entire internet under that framework that was originally developed for the Ma Bell telephone network back in 1934. So that's why we're glad that the FCC is undoing all of that and handing authority over the internet back to not just the Federal Trade Commission, not just the Department of Justice, but also the state attorneys general. It's really important here to emphasize that even if you have no confidence in a Republican FTC or Republican Department of Justice, the states can bring those cases too. And it's true that they do have fewer resources, but if there's a problem, they'll sound the alarm about it. We'll know. And if they themselves don't bring enforcement actions, it's going to be because there isn't a problem that's actually legally cognizable. So since I don't have a lot of time, I'll just wrap this up by saying that while I'm very glad to see that the FCC is undoing those claims of legal authority, and while we will continue to argue in court that the agency should not get deference in claiming that kind of authority over the Internet, ultimately, the FCC here is going to win the next round of litigation for the same reasons that it won the last round, which is that Chevron deference. And unfortunately, that also means that this issue will revert back in the next Democratic FCC. They'll claim the same broad sources of authority over the Internet. So we're going to continue arguing that the Supreme Court should recognize that this is a major question, that Congress has to act, and that absent legislation, that the FCC should not be able to claim that authority over the Internet. But unless the Supreme Court takes that up, ultimately it's going to be up to Congress to resolve this issue. And so I hope that as we see over the next few years that the FTC, the states, and the DOJ can deal with this issue, I hope we have a way of making that permanent in legislation. But one way or another, that is ultimately the way we'll resolve this fight.
Thank you, Barron. I do think it's important to start with the legal authority issue. So thanks for that. Not sure what that was. I think next I want to call on Steve. Steve, do you want to, I'm sure, add to your introductory remarks and say a bit more at this time, and then we'll move right down the line?
Well, thank you. I'm actually going to defer to the rest of the panel, but since you gave me the opportunity, I'm not going to pass up the mic for a second. Just to put on my economist hat, as I'm looking back at where we were, I think there is an important issue that we need to think about when we look at Title II regulations, some of these onerous regulations. The reality is that governments can fail, and government regulations can be imperfect and very costly. For example, when we look at onerous regulations, they can permit errors on what might be good market conduct on the one side instead of remedying bad conduct later. And these sorts of Type 2 errors can be very costly. And they create uncertainty in the market, which chills investment. They can increase various costs and fees and cross-subsidies. They can take away opportunities of value. They can limit service and price differentiation, which is important for maximizing consumer welfare. And then they can lead to rent-seeking and gaming, and we're seeing some of that. With that, I'm going to turn it over to the panel and let them handle the rest of this. Thank you, Randy.
Okay, why don't we hear next from Shane Tews. Shane?
First, I'd like to thank you all, because I'm sure that you have taken many emails, phone calls, and then had a lovely Thanksgiving, probably like I did. I thought I'd cleared the hurdle, and then my dad said a day later, explain to your brother why we don't like net neutrality. And I'm hoping, I want to say that by December 14th, hopefully this issue will be somewhat resolved so I can move on to explaining to my uncle the tax bill. It's always fun at the holidays. I just want to review real quick the three bright line issues that have been brought up. And a lot of people say, well, that seems like a pretty natural thing. We don't want the, no throttling, no blocking, no paid prioritization. First, most of these things have already been agreed to by the ISPs under other agreements that they've made with the Federal Trade Commission, and some of them in merger acquisitions. But there's also reasons why you might want to do any of these three things, and I want to highlight those. And with the idea of the transparency being in place, you would understand, hopefully, why, if any of these things took place, it was happening. We'll start with no throttling. I do a lot of work in cybersecurity, and denial of service attacks are a major reason why we have cyber attacks. So there's no busy signal on the internet. You don't ever get a sorry, can't go there right now. It's just a constant throughput of whatever that you put into the system. So if you don't have an ability to throttle or block, it is one of the reasons why we had the major IoT problem last year where they were able to take baby monitors and garage door operators over. So if you can see that on the system wherever you are in the stack, and you might be the ISP, right now the ISPs can see that and they have to let it just wash over them. And so ideally they can be a more proactive part of the cybersecurity protection that we're going to need, especially in the future as more and more machine-to-machine devices come online. The no paid prioritization, again, with transparency rules, this is going to be very important when we start looking at healthcare monitoring. We need very strong throughput, zero latency, or as close to zero latency as we can get, and reliability if we're going to use heart monitors. And a lot of the great things that we're seeing with 5G self-driving cars, one of the reasons why self-driving cars will work is because the information flow will be seamless. For the information flow to be seamless, we may need to prioritize the information that comes from the automobile over maybe your downloading of Netflix. Now, that won't actually interfere with your downloading a video, and I think there's a lot of misunderstanding that if you put something first, it automatically queues everything last, and there's been several papers I can point you to on that item. So those are the three bright line issues that really do have a reason for occasionally doing something of the throttling, blocking, paid prioritization. A lot of it is to protect the internet, which we haven't heard a lot about. We've heard a lot about killing the internet, but we haven't heard about protecting the internet. And one thing that's always sort of surprised me, especially when you're trying to talk to this with laymen, is that we've fallen into a European-style precautionary principle. We have a fear that these things are going to happen. They haven't happened. There have been maybe 2 incidents on the throttling. One was when Comcast was moving from one set of systems to another, and they really had a legitimate reason to do it. They just didn't handle it very well from a public relations perspective, perhaps. And then we've just had very early on when you had a lot of downloads of illegal content, and there was a point where the ISPs are trying to figure out how do we manage people downloading full-length, major motion pictures on the system, and throttling was very early 2000s, how they were managing that. So the precautionary principle is a little bit like that monster under the bed that your kid's sure exists, and his proof point is that Stevie has one too. So I think that we have to kind of look at why we're looking at these ideas and when is an appropriate time, if any, to use any of these 3 bright line issues. As Barron pointed out, the new online consumer protection MOU that the FTC and the FCC have said they'll enter into later this week is very important because it puts this back from taking the precautionary principle of fear of things that might happen, which very often does impede what we need to be happening in technology, which is innovation, and looking at the very specific cases of what is actually happening and what do we do to make sure that is not more than one case, that one case is prosecuted, and FTC is the place for that to take place. Just another point, and then I'll hand over the microphone, is a lot of times you think that you're having problems with your issue because the ISP is the only thing that you have a real you understand that the speed is coming from them, and the FCC is looking at upload time and download time. But what we're not actually looking at is the load time of the web. So next time you're sitting in front of your browser and you're like, God, this is taking forever, we expect things to load within 3 seconds. And in that 3 seconds, if you look at the websites, especially news websites, they're probably hitting 140 different domain names. They average about 5,000 pieces of information. And if that doesn't load in 3 seconds, there's abandonment. So we're asking a lot of every level of the system. And what we really need to have happen is that we are working on next generation networks that can provide us the internet that we're all looking forward to having today and the next generation.
Shane, thank you very much. Last but not least, as we say, we're going to call on Katie McAuliffe. I'll just say, most of you probably know her Twitter handle is @DigitalLiberty, and I have to say that's very, very apt because she's a great promoter of digital liberty. So we thank you for all of that. Go ahead.
Well, thanks so much. And thank you all for coming out to listen to this conversation. I think we're hearing a lot of the theme of transparency, transparency, transparency. And one of the things that I think is great to point to is this is the most transparent FCC that we've had. I mean, if you look at this, we've had the open internet, the Restoring Internet Freedom Order out 3 weeks ahead of the meeting, whereas the open internet order we didn't see until was it about a week after it was voted on? 2 weeks, excuse me. So this kind of transparency has been really helpful for us to continue to have this discussion in public and to talk about how this is going. So when we're looking at how this chairman, particularly under the previous administration, he talked about transparency, and now he's definitely practicing what he's preaching. as are the other commissioners. So we've had the opportunity to review this and talk about it. And looking at transparency, it's very important because this isn't saying that there shouldn't be someone regulating conduct. As both Barron and Shane have talked about, you've got the FTC and you've got your state attorneys general. The transparency rule gives both of these entities a tool to go after bad actors, but we don't want to be in a setup where we're presuming harm before it happens. So that's the kind of thing that precludes any kind of, or a lot of the innovations going forward. I mean, you think about where we are going to be, we can't even imagine. Before the iPhone was here, we couldn't have imagined what that was going to be. So setting these kind of regulations in place before anything has happened would be problematic for our innovative future. So that's kind of the first point on transparency. We don't want to freeze things where they are. And when you talk about applying utility-style regulations to the internet's only been around really commercially for 20 years. And you look at the innovation on the internet and then compare that to our utilities, which you would say are electric, sewage, water, controlled by the government. They're regulated, the speeds are regulated, the networks are regulated, the rates are regulated. Those are all set not by market demand, not by what customers want, but by what the government thinks should be happening. And I think from that example, it doesn't translate well to the internet. So in looking at those things, I think we are wise to have a rule that responds to bad actors and doesn't presume that people are doing things wrong before anything happens. And I think that's just a better system to be under. Another aspect of the rule that I wanted to touch on was preemption. So we saw after the Title II rules went into effect in 2015, a number of states coming forward with their own rules that actually amounted to data localization. And that's a major problem worldwide. We've all talked about it. You don't want to see the internet balkanized and broken up with data stored in different areas. We want the internet to be seamless. We want information to flow and people to have access to that. If states start drawing borders around their own internets, creating their own privacy rules, it really interferes with interstate commerce. So by going back to Title I, we avoid that issue. And also the FCC has clarified that the internet is an issue of interstate commerce, and the FCC has authority. This doesn't conflict with anything that happened before when we talked about, some people might bring up the issue of municipal broadband, where we told the FCC, hey, you can't mess with what states are doing there. Well, that was because the FCC was intervening in how states were managing their budgets. So a state actually creates the localities within it. Localities have no constitutional protection to exist. They are a manifestation of the state and the state managing its own budget. So the federal government does not have a right to come in and tell a state how it should manage its internal government in that aspect. So these are not the same kind of thing. We're talking about an interstate commerce issue. And in talking about privacy, we don't really want to have states making these kind of rules. We do want the expert agency, the FTC, to be working on this. In fact, right now they have a workshop going on about informational injury, and the FTC has been looking at these issues for decades, talking about how data should be used, about privacy, and we don't want to preclude different business models before they should come up. We don't want to hamper unlimited data. We don't want to prevent an instance where perhaps we could be compensated for the data that we're exchanging with companies. I think that would be very problematic, and some of us might really like to get paid for surfing Facebook all day. So I'll just stop there.
Katie, thank you very much. I was glad you mentioned water. You did during your presentation, because it reminded me in Susan Crawford's book, she's one of the leading opponents or pro-net neutrality advocates. She, flat out and unabashedly said that she thought that the internet should be regulated just like we regulate electricity and water delivery. And, when you think about it, water just hadn't changed that much over the last, couple thousand years. But the internet, changes almost weekly. So I think that makes me wonder whether that's really the way that the internet ought to be regulated. So what I want to do, and you guys in the audience be thinking of questions, but let's do this. I want to touch on the investment. I know Commissioner Carr mentioned, one of the important considerations for repealing the regulations is the impact on investment. And at a time when our economy needs more investment, that's awfully important. I'll ask the panelists, any of them, but I know Steve is certainly an acknowledged leader in the economics field. Steve, do you want to just explain succinctly, if you can, why the current regulation does have an impact, if you think it does, on investment by the ISPs?
Yeah, well, first we've observed it. If you look at the decline that happened within several quarters of the decision itself, and also an absolute reduction in the number of broadband wired lines on the telco side. We've observed that. We've had testimony from a number of small ISPs who have indicated the same thing. And the reason really gets back to what uncertainty does to the market, increasing the cost of capital, a number of the other issues that I mentioned before. When you get into this mentality that says, you can commit an error based on, your conduct, which in the end may be good conduct. What you end up doing is you snuff out good innovation at the risk, rather than later on coming back and saying, hey, in retrospect, was this the right thing to do? So this kind of thinking is a little bit backwards, and it creates this uncertainty in the market. It raises capital costs, and it chills investment. And so it's really as simple as that. It gets to be a sort of a matter of increasing industry costs, and those costs flow through to consumers in the form of higher prices. And anytime you shift that supply curve, not only do you get increased costs, but you have restricted output. And that's what you would expect. I mean, that's sort of basic microeconomics. And unfortunately, that's the problem with onerous regulations. Now, looking at these things after the fact to say, hey, is somebody stepped out of the bounds of something like that? That's why we have antitrust laws at the DOJ and the FTC to come back and take a look at whether or not there have been some violations. But to do that, as I said early on, before you not allow internet service providers to experiment, then you're not going to get experimentation. You remember the free minutes you would get on the phone? And there were a lot of new plans that were coming out to provide free minutes so you could watch ESPN and various other online providers. And the FCC indicated that they may look at those a case-by-case basis. Essentially, you can't give away minutes for free. Now, how do consumers benefit? How do consumers benefit from plans that offer free services? But I don't want to go any further, really. The point is, when you do something like that, you chill market investment. I mean, what investor wants to take a risk at something when they don't know whether or not the investment they made will pay dividends? We're talking about long-term investments that people have to put in the ground, and then they short-run decisions. As Randy made the reference to water, as the internet runs at lightning speeds, we have FCC policy potentially moving at glacier.
So I agree with that characterization, but I want to be really clear here. The problem isn't net neutrality. Right, so let's distinguish between three things. So net neutrality is a value or an operational state, right? So privacy is on the same level as that abstraction. And then there's the question of the specific regulations that were put in place. And then there's the underlying question of the FCC's authority. So the problem here, the thing that had the effect on investment, the reason that the FCC had always been reluctant to impose broad common carriage regulation upon the internet across Democratic and Republican chairmen was the concern that about that larger uncertainty, which is not really, again, about net neutrality. It's what happens when the FCC opens that door. So I want to be really clear here. The FCC will have said, the last chairman said, oh, don't worry, all we're doing is we're just using Title II, just a little bit, just to do net neutrality, so don't worry about it. You can't have just a little bit of net neutrality anymore, just a little bit of Title II any more than you can be, as the old saying goes, just a little bit pregnant. It's really one or the other. And the reason is that the FCC said, well, don't worry, we're forbearing from the rest of Title II, so don't worry about it. Well, that forbearance decision can be reversed just as easily as the FCC made that initial decision. And moreover, the FCC, when they said, well, don't worry because we are not applying all these other parts of Title II, well, what they did apply was the core of Title II. Section 201B is about just and reasonable practices, and 202A is about discrimination, right? That is common carriage regulation. Everything else is just more particular implementation of that. Once you have those two things on the table, you are regulating broadband providers as common carriers. You're doing what Bill Kennard in the late 1990s warned against, the very thing that caused Julius Janikowski, the other Democratic chairman who considered but decided not to apply Title II. Those are the things that have the effect on investment, and the only way you remove that uncertainty is for the FCC to disclaim that power, and then, as I said earlier, for either Congress to take it off the table permanently or for the Supreme Court to finally rule on that issue.
Okay. Yeah, no, I think what Barron was referring to was Chairman Bill Kennard said that he didn't want to dump the whole morass of public utility regulation on the broadband pipe. I think that was a direct quote, and he was prescient in that. So I want to ask this question. Maybe anyone on the panelist or more than one can answer it. You know, we've seen so many instances recently where the edge providers, Google and Facebook and Twitter and others, where they, you know, quote, discriminate or take actions that are not neutral. You know, they wouldn't be considered net neutrality as some of us think about that. Chairman Pai has actually, in the last week or so, he's provided all of us with a list of a bunch of those actions. So, and those are the advocates, of course, that are out front in advocating maintaining Title II regulation. And I guess my question is this, and I'll just say for myself to be clear, I've never advocated regulating those companies or restricting their speech. I don't think that should be done, but it does. There is a situation here where you've got differences in their actions and how you think about those in terms of, net neutrality or neutrality. So I guess I want to ask the panel, and maybe this goes back to the FTC thing, does that trouble you at all, and what do you think, if any, the answer should be to put these two types of firms that are in the internet ecosystem, as we say, on an equal footing, if anything? Who wants to?
Well, I think one of the things that's important is the system's global. And we all need to be working together on this. So when you think about what Twitter, Facebook, Google, and Apple, especially in China, are going through, it does have a warning system of the challenges that we have for the internet ecosystem, especially from an internet governance perspective. The idea of internet governance and that we all are part of a multi-stakeholder process is something that we have an appreciation for because it very much falls in line with our Constitution. The rest of the world doesn't see it that way. So, I can understand why people, again, going back to the monster under the bed, have a fear because they see what's going on in Russia or China, or the way they're saying, we just want to be able to handle our system in China, thank you very much, which they're doing. And the fact that we see that as an interference in what would be our First Amendment right. But that also doesn't, but one of the other things that is happening is that they're having control of the system means they can also help from a lot of the bad things that are happening. And, as we saw with, the Russians in the elections, at the very beginning, we didn't have a clue how that was being, managed, and we're all learning at real time. And that's important at every level of the network stack, including the edge providers, that we're learning how to protect the system and protect the internet of today, because I always say in 2020, I want the internet to be as cool then as it is now. I don't want to be in 2020 thinking, remember the internet? Yeah.
So to follow up on that too, at any point we don't really want to diminish property rights. When you're looking at the ability to control networks or to control your platforms, those things are important. And in going back to principles that can be applied across the entire ecosystem, limited government, that its role is to enforce contracts, deter fraud, and arbitrate disputes is what the FTC transparency rule, what the FTC process leads to. So in that way, you can respect a platform's ability to moderate or manage what is going on their platform. You can also respect a network's ability to moderate what's going on through their networks, to manage for reasonable network management, and those sorts of things. So if you're looking at, again, just the principle to deter fraud, to arbitrate disputes and enforce contracts, then I think that works pretty well across the entire ecosystem.
Well, and it's more than that. The FTC has, as the states do, has broad authority to protect consumers from unfair practices as well as to police competition. So no one here is saying that we should have a no man's land of lawless internet. The FCC, the FTC and the state AGs and the Department of Justice, actually all of them have quite robust power to protect consumers. We focus on the FTC. My own work focuses on the FTC because it really is the de facto federal technology commission. It has broad authority to deal with new technologies as they develop and to deal with new problems. I always smile a little bit when people say, oh, well, but how will we protect consumers without specific rules on the books? Well, the whole point of creating the FTC was to give them those broad standards that they could apply case by case and to build a common law over time to address those issues. I have my own criticisms of how the FTC works. I think it's becoming more important in this space, makes it more important that we talk about those processes, but no one, including me, wants to tie the agency's hands. At most, we're simply saying that we should understand better how the agency works and make sure that it's actually building an effective common law, but it absolutely should hold companies to their promises, prevent practices that harm consumers, and punish practices that injure competition. And that approach, again, will be a back and forth between plaintiffs and defendants, both private plaintiffs and government actors over time, and we'll deal with problems. And importantly, if we find that there are gaps in that process, we'll legislate. That's what's always happened with the FTC. That's why Congress, why the FTC hasn't found it necessary to use the rulemaking authority that it does have since 1980 when issues have come up, like the Do Not Call Registry or the Children's Online Privacy Protection Act. Congress has passed more specific legislation. So that's the approach that I would trust in going forward, and I'm happy to have a conversation about how to do that in a technology-neutral way.
Okay, I'm going to ask one more question, and then I'm going to ask the audience whether they have questions. And This question, I was thinking about it when earlier the panelists were talking about innovation and how they thought that the current rules, the Title II rules, stifle or perhaps stifle innovation. And something that I've actually written about and sort of puzzled over for a number of years is this, in trying to understand why certain people and entities take positions in this proceeding. You know, Google and Facebook both have advocated maintaining the current rules. And for example, Google has said many times, I've actually been on panels like this in which they said it, and President Obama even said it last year, that they're not concerned about Google or Facebook, protecting themselves at all, because they're big enough to protect themselves. They're concerned about the next Google. I mean, Google says it's not really, doesn't need the net neutrality rules to protect itself. It's concerned about the next Google and so forth. And that always, having been around Washington for a long time, that makes me really wonder what's going on here. And, you know, I think that, in fact, these rules that are in place, this is what I believe, that those rules in place actually serve to protect the large incumbents of the net neutrality providers and make it more difficult for a new entrant, the next Google, the next Facebook, to actually be able to use the increased flexibility to gain a foothold and challenge those incumbents. But that's at least a theory I have. I want to ask the panelists, and maybe Steve from his perspective as an economist could take a crack at it. What do you think about the next Google theory?
Can I combine that with just kind of going back to the question on investment, and you're talking about stifling innovation. You know, because it looks the same to us when it comes across a device that looks similar to this, we don't always understand how much is changing both in the underlying infrastructure as well as at the edge. And so where there'll be network virtualization, software-defined networks that'll change things in the underlying, it's a lot of times only at the Google element that, you know, where we look at the browser that we see the difference in what's going on. And a lot of that is now, it's divided into apps. And so, you know, I think the one thing that we may see that's coming out of China is having one app that aggregates everything. So right now, where we're popping in and out, you go to Venmo, you come back into Facebook, or you may go over to WhatsApp for something. There'll be more of an aggregated app that will help you manage a lot of things in your life. You know, there's reasons why they're doing it in China, because they're monitoring everything that's going on. But there is an element to that is actually, it's seamless into how we manage things. So I think what we're going to see is probably a little more aggregation with the way that we manage our own individual financial services and our technology, as well as other things that go on there. So there's multiple things beyond social media and the just basic networks that we're looking at here.
Okay, let's see whether anyone in the audience has a question. And, you know, if you could just lean more in the direction of the question than the presentation, and that way we'll be able to get more questions in if we have them. And if you can identify yourself as well when you have a question.
Chamber of Commerce. I wanted to ask some questions specific to small businesses. We represent small businesses that don't have the purchasing power of some large corporations, and they depend very heavily on the internet in order to survive in many cases. Some of our members have expressed concerns that repealing the FCC regulations would put their businesses at a disadvantage because they're worried that their web pages will not be able to load as quickly as the web page for a large company that has great purchasing power like Target or Walmart, and then people will exit their website and not buy their product. Is that concern valid, or are they misunderstanding the impact of the FCC regulations?
So if they have a good web designer, they shouldn't be having a problem, because the zeros and ones don't know if the end user is sending it to Target, Walmart, Amazon, or the small business down the road. They're really, from that level in the architecture, it's a matter of, when I mentioned earlier, there's actually a report by a guy named Richard Bennett that talks about load time. So the best thing they can do is in front end invest and make sure that they're on a system that doesn't put too much on the front page. The one thing I would say that they have a concern with, that actually having your internet service provider could be more valuable to them, is using the cloud for cybersecurity. Small businesses are a huge target for ransomware, because a lot of times if you lock up their web presence, they're losing business. They're making no money that day or that week. And so that's become a very it's very heavy in the ransomware area, because they don't know what to do and they don't know who to contact. So if you had that ability to know that this is the attack of the week, and you can notify your customer base that you're going to do additional monitoring and maybe quarantine if you see something like that coming over, like the old conflict or worm, that would be where they would actually have a great enhancement. And to do that, you would have to be able to monitor systems, which the current rules under Title II, it's a little gray as to whether or not that's considered throttling or blocking.
Well, and to follow up on what something that Shane said earlier, when I think about the idea of net neutrality, is when I'm surfing the web, I think everything should show up equally, right? I shouldn't notice a difference between the way my email shows up or a web page loads, or when I'm FaceTiming with someone, or something else that requires latency. So, and Shane mentioned this earlier, prioritization doesn't necessarily mean that something loads slower. It means that in order for everything to show up the same way, some things have to get prioritized. So when you think about a video call that requires more data than it does to simply load a web page, and that is where an instance of network management actually happens, so that those things do appear seamless and they all appear the same. I wouldn't think that that would be a problem. And again, to Shane's point about your web page or how those are functioning, a lot of times the things that slow down web page loads the most are the advertising in the side and how much data there is behind that, whether it's video or those sorts of things. So there are a lot of other things to look at rather than Title II type rules. Title II is more about government control of the internet and what kind of regulations that state, local, federal government can put on the internet, and less about that seamless nature that your businesses would want the customer to experience.
Two answers, legal and practical. As a legal matter, remember, again, as the Commissioner said, under the FCC's own rules, if a broadband provider had wanted to essentially opt out of that framework and start discriminating, it could have done so. I want to make that really, really clear. If you thought that was a problem, Title II would not, in fact, address that problem. But as a practical matter, there is no market for doing what you're describing, and I don't think there ever will be. The concerns that the entrepreneurs that joined Tech Freedom in suing over the litigation raised were not about that. What they want is, they're in a very unusual circumstance of offering real-time, high-quality voice streaming, where what really matters is latency. So this idea that somehow it's websites are not going to load, or that someone will not be able to get the services that they want, that run-of-the-mill service is never going to be affected. We're talking about, on the margin, as Shane was saying earlier, some services being able to ensure that there is quality given to the delivery of their packets. That's why they were concerned, and you can do that without affecting the delivery of other bits.
I think we had did you have a question over here?
Yeah, I did. Thank you. Okay, hi. Tracy Rosenberg,
Use the microphone.
Okay, yeah, thanks. Okay, hi everyone. Tracy Rosenberg, I'm a consumer advocate. Two questions. First, when it comes to the question of broadband investment and its decline, which you've all spoken to, extensively. There are several ISPs, including two of the largest ones in the country, whose investments have not declined in the last 2 years. And that includes Verizon, Comcast, also Charter, Windstream, Mediacom. So I have a question in terms of whether we are somewhat overstating the both the amount and the impact of net neutrality regulations on broadband investment. Clearly, some of the largest ISPs in the country were completely unaffected. Second question is, I didn't hear anybody on the panel mention the current case with regards to AT&T and the FTC. AT&T, as some of you know, is an ISP, one of the largest ones in the country, and it went to court to remove FTC jurisdiction from itself. And this case is being called back for an en-banc hearing. It has not been resolved. So the question is, firstly, does it make any sense to revoke these regulations when you are relying on the FTC to do so much, and the FTC may not, in fact, be able to? And secondly, why didn't any of you guys mention it? It seems kind of relevant with all this talk.
Okay, I bet they'll mention it now. Those are two good questions. Let's take one has to do with investment, and then the other one has to do with the impact of the AT&T mobility case.
I'll leave the investment question to others. So I didn't mention the AT&T mobility case because I didn't have enough time, and it's pretty complicated. So let me just try to quickly walk you through this. So the FTC has jurisdiction over all companies in America except those that are specifically excluded from its jurisdiction, which includes common carriers. Now, until the AT&T panel decision at the Ninth Circuit earlier this year, the FTC had always understood that that meant that it was activity-based. So in other words, if you were a company that offered a common carrier service and a non-common carrier service, the common carrier service would be regulated by the FCC or whatever agency was regulating you, and the non-common carrier services would be left in the FTC's jurisdiction. Now, in that circumstance, it would be a very clean transition. Once the FCC undid common carrier reclassification, the issue would simply transition smoothly back to the Federal Trade Commission. Now, the lady is correct, and I'm glad you mentioned that the panel decision would have created some remaining issues. So the transition would work, but a company that offered both services, like, for example, Google Fiber, offers broadband service as well as now a voice service. And so there was a concern that a company like that would still be in the FCC's jurisdiction exclusively because its status was that of a common carrier. And then the non-common carrier services would not therefore revert back to the FTC's jurisdiction and would fall into a no man's land. That's the concern. Now, the thing is that the full en banc Ninth Circuit, when they decided to rehear that case, so not only does that rehearing suggest that they think that the underlying panel decision was mistaken, and therefore that the full Ninth Circuit is not going to reach that conclusion, but they took the very unusual step of actually vacating the underlying panel decision. So that panel decision essentially never happened. Now, it's still a question, and it is possible that the FCC might ultimately lose now, and that AT&T's argument might prevail. But it's extremely unlikely. And it is essentially the same likelihood as before, because now that question is going to exist. It's a theoretical question, and it is possible that another circuit might find that. But if you're concerned about that, then the answer here is for Congress to clearly legislate. That's a one-sentence bill that simply clarifies that the previous understanding of the common carrier exception is correct, or that repeals the common carrier exception, which is something that Democrats and Republicans have long called for. But it's an easy fix, and it's something that, again, is very speculative at this point. And even if it did happen, even if the Ninth Circuit, full Ninth Circuit, somehow upheld at least part of the panel decision, that would only apply in the Ninth Circuit. So apart from Google Fiber, I'm not aware of any large ISP that's based in the Ninth Circuit. So the law everywhere else in the country would be the same. So it's a fair point, but it's pretty speculative. And until the Ninth Circuit issues its decision, which could happen pretty soon, there isn't a problem. And again, if there were, Tech Freedom would be one of the first organizations going out and saying, as we've said in the past, that Congress should legislate immediately. And even this Congress, for all its dysfunction, I think can pass that one-page bill pretty quickly.
Okay. Well, that was a thorough explanation of that point. Let's see whether anyone wants to say anything about the investment point.
On the investment, first of all, we don't want to see investment go down, even though there have been several studies that have shown that. And part of the challenge for that is an apples-to-apples comparison, because not all these companies do the same thing. So I'm glad to see if Charter is putting more money into their, into their system. That's good for all of us, especially consumers. They're not the only ones that we are concerned about, though, because you need to have investment in fiber and people knowing that as we're going to small cell technology, that is, there's several companies that are going to be engaged in that are beyond just your regular ISPs. However, there are several studies that show that there's, this was a challenging year for them. The last 2 years have had a decline. But again, that we're looking for an apples-to-apples comparison as to what these companies are doing.
If I may, just to make a point too, the number of the companies identified have had mergers. So when you go to their corporate data, you're going to see Charter is merged with another large cable company. Verizon is merged with AOL and Yahoo. And so what you're doing is you're adding in their base level and you're comparing it. And so I would suggest also going back and making that correction to the baseline.
Just to add to that, really briefly, I think when you're talking about investment, it's really important to also understand that it's not whether you have some absolute increase in investment or decrease. I believe the studies, a number of credible studies have shown there's been a decrease, but really the way you want to think about it is whether there's less investment than there otherwise would have been absent the regulations, because you might have increasing investment, but if it's less than it would have been absent the regulation, then, and you don't need the regulation to protect consumers, if you assume that may be true, then that's not good. That's harmful, really, to the economy when you think about it in a cost-benefit way, really. Okay, did you want to add something?
Yeah, I can follow up on that with exact numbers. I just pulled up the study here was from the Phoenix Center, which very interestingly compared investment before 2010 when the rules were first talked about, and then after 2010, and showed a decline. Fixed assets would have been about $30 billion more annually in equipment, and property would have been about $20 billion more. So just with that uncertainty and the threat of reclassification, it decreased investment. So that doesn't necessarily mean that there, as Randy said, and other folks have said, that there wouldn't have been investment, just that there would have been more.
And in that specific study, I believe they compare it to other industries. So again, they're trying to find a baseline that is even for everybody.
Is there another question from the audience? Do we have a question? Well, maybe okay, up here in the front row, just a minute, and I think he's going to bring a mic. Can you identify yourself?
Spectrum and all that's the language that you guys talk about. Yet, we want to have Congress try to resolve some of our regulations, and Congress may pass a tax bill, or they may decide on immigration. There's some very simple things that they're not willing to because of politics. So we're going to allow politics to overshadow technological knowledge. Hopefully, commissioners have some of that. What are we going to do? Not Title II, what are you going to do?
Well, again, Title II doesn't actually do any of the things that everyone claims it does. It is the D.C. Circuit, in upholding the Title II reclassification, described that regime as a voluntary one that consumers, the companies could opt out of. So If you're concerned that there's a problem, I reiterate to you that Title II is not, in fact, the solution that you think it is. If what you want is a clear legal basis for addressing this, we've supported net neutrality legislation for years and would continue to do so. I happen to think that it's better for that to live at the Federal Trade Commission. But I'd be happy to codify the underlying core rules. If people are concerned, if that's the issue, that people are concerned that case-by-case enforcement alone isn't adequate or makes it too difficult for a small company to bring a complaint, we can, and there's been bipartisan consensus on codifying a rule against throttling and a rule against blocking and so on and so forth. But I think that should live at the FTC. And ultimately, the hard question is what you do on the margins about things like giving away free data. There are all sorts of harder cases. The case that I've mentioned about our fellow interveners who are concerned about the effect on VoIP services, those are all things that you need, in my opinion, some flexible standard to deal with. The one that Google itself negotiated with Verizon back in 2010 is effectively an FTC standard. It's a standard of dealing with meaningful harm to consumers. I think that's a great solution to the problem. We could put that in legislation, and that will resolve these debates once and for all. But the sky's not going to fall without legislation. The FTC, the states, and the DOJ are going to police against real harms and hold companies to their promises in the interim. And that will be fine for as long as it lasts. And unfortunately, it may only last until the next Democratic FCC, where we may be right back to where we were last year, absent legislation.
And I would say that we do have a regime under which Title I that we should be following. The clarification of interpretation on this would be helpful from Congress. The discussion as to what to codify would certainly come up in the future, and there have been bills discussed. And I don't think that talking about politics or the slowness of Congress is a good way to look at that. I mean, our legislative system is designed as it is for a purpose, and the FCC is a creation of Congress. So to just start putting out rules from unelected bureaucrats who don't have that as much accountability is really not the direction that we should be going on that. There are, when we look also at the way at consumer response to things, companies respond to that very well. We've seen that a lot in the past year when people have expressed certain opinions about a corporate CEO or about a product or about a store having a particular product. Well, I might not agree with those inclinations. Companies do respond very well and very quickly to consumer preferences. That would just be my addition to that.
Okay, well, I think our time is drawing nigh here. Unless anyone has one more question. Okay, I see one in the back, and we'll take that, and then I think we'll wrap up.
Congressman Gomez's office, and over the past couple of weeks we've been getting a lot of calls from constituents who are really concerned about their prices going up for internet access. So I just want to see if y'all can maybe give me some information on that.
So on that point, I would say your prices are not going to change any more than they would with the market as it is. I mean, looking at this is the same trajectory from Title I. We're going back to the internet from a year ago, 2 years ago. There have not been any major changes. When you see prices change, I mean, an interesting thing about the transparency requirement from Title II, and I don't even know if this has been worked out, when companies disclose their prices, they're not required to disclose what the taxes and fees are on top of that. And when I worked on the Consumer Advisory Committee at the FCC, and we were working on the broadband label, it was decided that it would be too difficult to include state and local taxes and fees on internet access because there are too many of them and they're too varied. So one of the important things for transparency is what is the government charging? And we just had a study come out from the Tax Foundation about how high mobile taxes are. I mean, in some states, on your mobile phone, taxes can be up to 22%, and that's well above the average sales tax rate. And those are with Title II, as Barron said, that doesn't prevent any of the so-called net neutrality tenants. Title II doesn't enforce those, but what Title II does add is more government involvement, more ability of state and local governments to add fees, more ability for states to carve up the internet at their borders, and that's not something that we want. But within a Title I framework, we can, as Barron has talked a lot about, rely on the FTC.
Two really quick things. The government's ability to tax broadband, to impose universal service contributions, which are effectively taxes, actually depends on Title II classification. Now, the FCC, the last FCC was smart enough to wait until after the election to drop that shoe because they realized it was a loser. So that's the only reason that hasn't happened yet. So that is actually the thing that would have raised prices for broadband. And that will not be possible once the FCC undoes that Title II classification. But regardless of that, let me just point out the irony here is that now people are saying, well, prices might go up, even though that doesn't have anything to do with net neutrality. But remember, the last FCC assured us that they weren't going to use Title II to regulate prices. Now, that, of course, is the fundamental concern, because price regulation is the essence of common carriage. And as long as Title II is on the table, that is a very real thing. Now, in my opinion, price regulation tends, in fact, to drive up prices. But that is the argument the other side is making now, having said before that they would never, ever dream of using Title II to regulate prices. So if that's the concern, the real answer is to promote competition. And the FCC is doing a great deal on that right now in the Broadband Deployment Advisory Committee to work on broadband deployment. There are things in that department that the FCC can do on its own. There are other things that Congress will need to do. And that's, again, where we are going to be pushing legislation. There are flurries of bills out there now that have broad bipartisan support. And that's where we should be focused.
Okay. Well, on Thursday, let's see, today's Tuesday, and on Thursday, the FCC will be meeting on this. I think we've really covered the waterfront, and we've been fortunate to have an expert panel here. We've talked about the legal authority of the FCC and all the various policy aspects of the decision confronting the FCC. So hopefully you agree with me that it's been really educational to do that. My hope is that going forward, the FCC will remain an institution where we value the expertise of the commissioners, whether we always agree with them or not, and it not really become a place where we think it is or ought to be influenced by who's got the largest protest at the front door, or whether there are a million more comments here or there. Because if we do that, then actually it will be devolving really into a political institution, and the place for politics is more appropriately right up here, I think, in Congress rather than over at the portals. So with that, I want to thank Steve and the American Consumer Institute again for sponsoring a program that's so timely and that I think has been so educational. And join me in thanking our panelists here today, please.
Thank you too, Randy.